Well, lawmakers say they plan to take a closer look at how Colorado's competency law and changes made last year are working.
Those laws are being scrutinized by the public as well as local DAs and law enforcement. It comes after Weld County officials say those laws are at least partially to blame for the recent release of a violent criminal back into the community. Your investigator, Karen Morfitt, has more on this case and the law at the center of this debate.
Public outrage over the release of a man authorities in Weld County say is a violent criminal is personal for Griselda and her family.
He was just brutally beaten after he was unconscious.
Her brother, who she asked that we not name, is the victim in this video from April.
He had to learn how to talk again, how to walk again, how to do all of the basic functions.
Debiza Ephraim was arrested and charged with attempted murder. Despite a history of assaults, burglary, and theft arrests, the case was dismissed.
I was not aware of this law, and I think many Coloradans are still not aware.
Weld County District Attorney Michael Rourke says his hands were tied after lawmakers and the governor signed House Bill 1034 into law last year.
It mandates the dismissal of charges against defendants when they have been found incompetent to proceed and not restorable.
The case caught the attention of Elon Musk on social media. Governor Polis responded, saying it's unacceptable and that the DA should have done more.
I'll tell you what my response is to the governor's post. It is completely inaccurate.
Civil commitment does allow for involuntary detention or treatment if a defendant is a danger to themselves or others and has a mental health disorder.
There is a very specific definition of what constitutes a mental health disorder. This particular defendant did not meet that definition.
Rourke says lawmakers need to consider changes.
The civil commitment statute is entirely too narrow to be utilized in this fashion.
State Senator Judy Amabile, who sponsored the bill, says state and federal law already require an incompetent, non-restorable offender to be released from jail. This bill requires dropping charges as well.
And so it was to ease this transition into the civil system.
She says there is more work to be done.
If you have an intellectual or developmental disability, if you have Alzheimer's, if you have a traumatic brain disease or a traumatic brain injury, those things are not considered mental illness. And so you cannot be civilly committed in a Colorado state mental hospital because those things don't qualify you for that. So what we have failed to do is to set up an alternative path for people who are in that situation.
In the meantime, victims and their families say what's happening is unacceptable.
Just protect yourselves, public, because we can't do anything. That just sounds insane.
Griselda fears the worst is yet to come.
It's scary to think about what's next.
The governor issued the following statement after DA Rourke called his tweet inaccurate. He says, in part, quote, "I support local governments in using every tool they can to protect public safety and have made state staff available to work on options in partnership with local governments to ensure dangerous individuals are not released into the community. I also support updating statutes where necessary." I'm Karen Morfitt, covering Colorado First.